Good afternoon, members. Welcome to another CPD put on by the Law Society of Yukon. Today's CPD is an introduction to the creation of a condo development. Leslie McRae will present changes around the creation of a condominium development is resulting from the Condominium Act 2015. Leslie will take you through the requirements for developers, changes around survey, new rules on the sales of condos both for developers and as an owner of a condo. So to introduce our presenter, Leslie McRae is a longtime Yukoner, having arrived in Whitehorse in October of 1980, so 43 years this month. Leslie was called to the bar of Yukon in British Columbia in 2000. Since that time, she has practiced residential and commercial real estate, including lending and borrowing, and had a long career as Northwest Health serving as a chief legal counsel, general counsel, corporate secretary, chief privacy officer. Leslie was appointed as Registrar of Land Titles in January of 2021. And as a reminder, this CPD has been approved for 90 minutes by Law Society of BC and maybe used as your professional development requirements for in both Yukon and BC. Please welcome Leslie McRae.
So the new Condominium Act came into force on October 1, 2022, so just over a year ago. And it came along with, then it's not letting me advance. Oh, it's going to do it in a strange way. Just over a year ago, and it came along with many new regulations as well. So first of all, I just wanted to acknowledge with respect that the presentation takes place on the traditional territory of the Kwalendun and Tanquachan people. Thank you. This is basic information about the new act and its regulation. It is not intended to be legal advice. And as you probably tell your clients, legal advice is what you go to a lawyer for, not the Registrar of Land Titles. The presentation outline is going to include just a brief review of the legislation and the different condominium types, the steps involved in the land titles office to create a condominium, the change to how bylaws are viewed under the new act. We're going to briefly cover the sale of units by a developer, the requirement for reserve funds and reserve fund studies, the new provisions regarding first directors. And we're also going to just touch briefly on the requirements leading up to the first annual general meeting during the transition period and the developer's responsibility for expenses during that period, and also briefly on how the new act applies to pre-existing condominiums. So as I mentioned, the new act came with 6 new regulations: the general regulation, a regulation regarding reserve funds, regulations for different condominium types, bare land, for example, converted buildings, phased developments, and condominiums on leasehold land. We won't be talking about condominiums on leasehold land in this presentation, as they are quite specific. So the regulations and the act create some new rules depending on condominium types. Just going to pop up here and see if we've got any. Oh, it's telling me all kinds of things I didn't know. So to create a condominium, there's still a requirement for condominium plan, a declaration, and bylaws. But there's some new and different concepts that were not in the former plan. As you are no doubt not surprised, the condominium plan requirements are set out in Section 6 of the Act. The plan has to be labeled, the parcel has to be identified, the boundaries of the parcel and location of buildings on the land have to be delineated. Each unit has to be numbered and its boundaries defined, as well as the approximate area of each unit. Unit entitlements The boundaries of the common property and common assets have to be shown, as well as boundaries on a separate drawing of any areas of the common property that are used for roads, guest parking, wheelchair accessible parking, public utilities, recreation facilities that are shared by all units, and suitable access and services to all units. Those have to be shown in a separate drawing attached to the plan. I can assure you that I've talked to many of the surveyors about all these requirements and done a presentation for them as well. Oh, every time I move the little wiggle thing, there we go, I'm back. So what's new, there's a prescribed form for the declaration. All the new forms are also found on the Yukon Condos website. The schedule of unit entitlements, the schedule of voting rights, and notice of directors are now required. Schedule of unit entitlements is what we used to call the share in the common property or the share of common expenses. In addition, for different types of condominiums, there's special requirements. Bare land condominiums require a statement about the types of units and information about any managed real property. Managed real property was a concept that wasn't clearly delineated in the former legislation. An extremely detailed for phased developments, an extremely detailed disclosure statement is required. For converted buildings, there's provisions dealing with tenants' rights, as well as the requirements for a building assessment report and a reserve fund study prior to creation of the converted condominium. So a schedule of unit entitlements is essentially, as I said, what we used to call the share of the common property. It allocates to each unit owner a fair portion of common expenses. It has to be calculated in accordance with a method that is defined in Section 5, the general condominium regulation. So it's not just per square foot or per square meter. The schedule of voting rights sets out the number of votes allocated to each unit. There's a notice for address for service, a notice of first directors, and a notice of bylaws that are required. When we were communicating from the Land Titles office and trying to communicate with condominium corporations, boards of directors, we sent out a mail out to what we understood was the address for service of the condominium corporation. And several developers showed up in the Land Titles office, some of them with 3 or 4 envelopes in their hands. Why are you mailing this stuff to me? Well, that's the address for service on this title for the common property. So that's why we're communicating to you. It has never occurred to anyone, I suppose, to change the address of the condominium corporation from the developer's address to the address for the board of directors. So notice of bylaws, it's important to understand that under the new act, bylaws are not registered instruments. They are filed in the condominium index. Well, before we move on to bylaws, I see we have a Q&A. Let's see if I can actually open it.
So I've got it open, Leslie. So would you kindly set out which of these prescribed requirements may or may not be opted out of by agreement of the parties?
Prescribed requirements, none of them may be opted out of. When you're creating a new condominium, these are all the requirements of the act. So I'm going to close that. What has changed in the new act is that many matters that used to be dealt with in the declaration, and they're now dealt with either pursuant to the act. The act prescribes certain sections, certain requirements, I should say, or they're now dealt with in the bylaws, or the regulation prescribes certain provisions. So the declaration, if you've created a condominium prior to October 1 of last year, you might have had quite a long declaration, and your declaration is now going to be relatively short. It's going to deal with only the things that are required to be dealt with under the act. Bylaws, there's a must section, there's a may section, and there's a must not section. So first, they must include provisions for control, management, maintenance, repair, use, and enjoyment of the units, common property, and common assets. They must include provisions for governance of the board and administration of the condominium corporation, but don't overlook the fact that the Act itself, as well as the regulations, contain provisions regarding board governance. There's quite a lot about board governance in the Act. The bylaws must include provisions for insurance, and again, must be read along with the provisions in the Act relating to insurance. And it must include provisions for the interest rate that the corporation may charge on amounts that are owing. So if your unit owners don't pay their monthly assessments, for example. The may section may contain provisions regarding exclusive use of common property or assets. It may contain sections or separate bylaws for mixed use developments. Mixed use, for example, where perhaps part of the condominium is a residential and part is commercial. And those sections can have their own sets of bylaws and their own voting rights as well. Whether tie-breaking votes are permitted, the terms, conditions, and amounts of fines, you might normally think you'd see that in rules, but it can be in your bylaws. And also, how is the condominium corporation going to deal with expenditures that are not included in the annual budget or not approved by a special resolution? Those provisions may be in your bylaws as well. So I'm just going to stop here and see whether there are any questions about bylaws. I think one of the questions that I'm used to hearing is, why did the government decide not to do standard bylaws? The entire act is a balance between consumer protection and providing as much flexibility as possible for different types of living arrangements and condominium corporations. And the government did initially, I understand, think about creating a standard bylaw, but realized that it would be quite difficult to provide a bylaw for different types of condominiums. It would just become very convoluted to try to give enough choices. So that's why there's no standard bylaw. Okay, now I think people can't ask questions, they have to chat or Q&A, right? They can't just speak up. Okay.
No, that's correct. The chat and Q&A functions are open for questions also. We do encourage everyone to ask questions.
Okay. So not seeing any questions in chat or Q&A, I'm going to move on to the additional requirements when creating a condominium, specifically related to converted building condominium regulations. So the regulations require that the developer obtain a building assessment report that must be prepared by someone who's at arm's length from the developer, which details basically the condition of the building, specifically any defects or building code variances. The developer must also obtain a survey from occupants on whether or not they've observed any problems in the buildings. The approving authority, which is essentially the way the Act uses the terms approving authority, is referring to the subdivision approving authority, but what it really means is the municipal authority responsible for building. The building assessment report has to be filed with the application to create a converted building condominium, and the approving authority must give a certificate acknowledging that they've received it, as well as potentially what actions the approving authority is going to require to fix defects or variances. The developer also has to provide confirmation to the land titles office along with their application, notices of conversion, and if conditional offers or sale are required, that those have been given to tenants at least 6 months before submitting the application. So That's just confirmation. That's just a statement saying that they've been given. The land titles office does not require evidence of any kind. It's a statement which forms part of a schedule to the declaration. If the converted building is going to have more than 2 units, a reserve fund study is necessary. And that study, as well as the building assessment report, are required to be provided to any potential purchaser. So I'm just going to stop there and see. No, I don't see any questions there. So additional requirements for phased development regulations. These are quite detailed. The phased development disclosure statement from the developer must include a detailed description of each phase of the development, including a contingency plan. There are about 14 or 15 different elements that have to be addressed in the phased development disclosure statement. It may be necessary to obtain approval from the approving authority for certain of those elements. Excuse me. And a copy of the registered disclosure statement, and it does get registered as a separate instrument along with the application, must be delivered to a potential purchaser. Okay. Fair land regulations. There's some additional information that has to be included in the declaration, which is related to attached buildings and whether any portion of the attached building is managed real property. In other words, is common property of the condominium corporation. And then there's a special little requirement that if a bare land unit is one of a series and it has buildings, managed real property, in other words, it can't be registered until the developer provides evidence that the attached buildings are constructed within the boundaries of the unit. I have a question.
Is
Phase
the development statement required if the development is not created or constructed in stages?
It is not. A phased development is its own zebra. It's not a horse, it's a zebra. So if it's not a phased development disclosure statement is not required. So as I mentioned earlier, I'm not going to talk about leasehold condominiums on leasehold lands. They're not zebras, they're unicorns. I think we're going to get some, but I don't know what they're going to look like yet. It's going to be interesting. In any event, condominiums on leasehold land may only be created by public authorities. Public authorities are Government of Yukon, a municipality, or an eligible First Nation government. Here we go again. Okay, new requirements. If you are acting for a developer and they are selling units, they must provide detailed disclosure documents. What they have to disclose depends on the type of condominium development, the timing of when they receive the request or when they're making the sale, the stage of construction, and when the condominium was created. So that's all set out in sections 54 to 60 of the new act. There are also cancellation rights in sections 55 and 56 of the act. The purchase and sale agreement must contain a clear and obvious statement of those cancellation rights. Note that this does not apply to purchase agreements made before October 1, 2022. Don't know if there's any of those floating out there. But important to understand, this also applies to units being sold by a developer in pre-existing condominiums. So if the condominium was created before October 1, 2022, and the developer is still selling units in that condominium, these sections apply. Okay, just before we leave that, I'm sure I'd get questions about that.
So just a clarifying question. So, and it is something that might happen. So if an agreement to purchase a condo, say via security of a loan, was made before October 1st, 2022, those would not apply to that agreement to purchase.
No, that's right, because of course, you would have signed your contract to purchase and sale before the act came into force. And these requirements are only effective October 1, 2022. So you would have signed an agreement before there was any legal requirement to include these provisions in it. But what doesn't seem, based on what I'm hearing from realtors, what does not seem to be clear to developers is that if they're selling a unit today, even if the condo was created before the new act came into force, these provisions do apply. So these provisions regarding reserve fund that we're moving on to, they only apply to condominiums created after October 1, 2022. So because they're triggered by the first conveyance of a unit by a developer. Developer has to estimate the annual common expenses and pay 25% of that into a reserve fund. The Act indicates that an additional amount may be required pursuant to the regulations for converted buildings, but there is no additional amount. There's nothing in the regulation that deals with it. In addition, if the developer is selling a unit in a converted building that has 3 or more units, they must obtain a reserve fund study before the sale of any of the units. I think reserve funds are pretty well understood, even though they haven't been required by Yukon legislation. Most folks that deal with condominiums understand that insurance companies for larger condominiums have been requiring reserve fund studies and reserve funds for many years. An entirely new concept under the Act is the concept of the first directors, sorry. Developer is required to appoint first directors and continues to control the corporation until those directors are replaced by an elected board. Those directors have the same standard of care, the same powers and responsibilities as elected directors. They are potentially required to pursue construction warranties. They must keep the corporation's financial records and transactions separately from the developer's records. Again, these requirements only apply to condominium developments that were created after October 1, 2022. It's the responsibility of the first directors to prepare an interim budget for the first 12 months that starts on the transition period. The transition period is triggered by the sale of the first unit. It starts on the first of the month following the sale of the first unit and ends on the last day of the month in which the first AGM is held. That's the transition period. Also a new concept. Every time I do that, I'm gonna have to do that. There we go. It's the first director's responsibility to convene the first annual general meeting within 6 weeks after 51% of the units have been sold, or within 9 months of the sale of the first unit. There's a lot of tricky timing in the transition period. The developer who is responsible for obtaining the first insurance policy must ensure that the term of that policy doesn't expire for at least 4 weeks after the first AGM. After the first AGM, the first directors must transfer control to the elected board, and there are penalties attached for failure to convene the first AGM when it's required to be convened. So the developer is responsible for expenses during the transition period. So if those expenses exceed the amount shown in the estimated budget, it's the developer's responsibility to pay those expenses. There again are penalties attached. If the difference is greater than 10% from the estimated budget, then the developer must pay full amounts, penalties. Moving on, just let me double check. Moving on to pre-existing condominiums. So section 239 of the new act is the section that sets out time periods for transition, different concept of transition here, that allow pre-existing condominiums that were either created before October 1, 2022, or condominiums who applied to be considered as pre-existing, applied to be considered as pre-existing condominiums before October 31, 2022. So if a condominium was substantially advanced, and that just doesn't mean substantially advanced in terms of its construction, but in terms of its readiness to file documents in the land titles office, they could apply to the land titles office to be designated pre-existing. I think 5 of them did. So there's 5 condominiums that were all created within the month of October 2022 that for the most part are governed under the former act rather than the new act. Okay, so here's the provisions for change of control during the transition period. There's 3 time periods. The first one starts the date the condominium is registered, up to the date before the transition period begins. If you remember, I said the transition period begins on the first of the month following the sale of the first unit. And then the third column is who's responsible for what. The second time period is the transition period. It starts on the first of the month following the sale of the first unit, ends on the last day of the month following the first AGM. And the third column again says who's responsible to do and pay what. And then the third time period is post-transition, once the transition period is complete and the elected board is in place. And that starts on the last day of the month following the AGM to allow time for the first directors to transfer information and responsibilities to the elected board. And then again, the third column is who's responsible for doing what. By this time, of course, the expectation is that since at least 50% of the units will have been sold, the condominium corporation is collecting its monthly condo fees sufficient to fund its own operations. So that is the end of the presentation. And I just wanted to let you know, there's you probably already know this, there's a website called www.yukoncondos.ca. And on that website, you will find all of the forms that you need to use under the new act, as well as some information sheets on some specific subject matters. One of the most helpful documents that I think that we developed and published is the key timelines. It's a sort of 11 by 17 poster that describes the transition periods and specifically deals with when the new insurance requirements come in for various condominiums, and when the reserve fund study and reserve fund provisions come in for pre-existing condominiums. So if you're giving advice to pre-existing condominiums, that's going to be a very helpful document for everyone to look at. So I'm just going to pause here to see if there are any questions. I still see any. Lynn will be sending out this presentation. I'm sorry that you weren't able to have a look at it beforehand. Once you've had a chance to think about it and look at the presentation, if there is, and if you do have any questions, please just get in touch with me and let me know. If not, then I'll say thank you very much. And thank you, Lynn, and to the Law Society for letting me do this.
On behalf of the Law Society CPD Committee, this is Bruce again. I'd like to thank you very much for attending our presentation, and of course, as always, thank Leslie for taking the time out of her busy day to come and present this information to us. As a reminder, Leslie will be joining the Law Society again on November the 8th at noon. And at that time we'll be presenting an introduction to condo governance. So if you want to see what the next
Longer
step
presentation.
is, come please we look forward to seeing you on that day. Thank you and enjoy the rest of your day.
Thank you. Bye.